What's the deal with this new alimony rule in Massachusetts? Hi, I'm Bill Farias, founder of Farias Family Law. We are in August of 2022 and a new case just came out. It's called Kavanaugh, and it has the potential to have a significant impact on how alimony is calculated in Massachusetts. The caveat here is that this case is brand new and it's going to take some time for this case to gain some traction and for the divorce bar and the courts to gain some clarity on exactly what this means. But here's what happened. The court issues a decision that basically says you cannot assume that just because all of the money that the parties have in income is included in a child support calculation, that money cannot also be used for an alimony calculation. And so the reason for this is that the fact pattern in this case was that this guy was paying child support to his wife, and the full amount of his income was used for purposes of calculating child support. And so when the issue went back before the court and he was asking for a decrease, the wife counterclaimed and asked for some alimony. And the judge said, sorry, we can't give you alimony because all of his money is already being used for child support, and the child support rules say that, the alimony rules say that if money is already being used for child support, it cannot be also used for alimony. And so that was the situation, and the court takes a look at this fact pattern and says, no, that's wrong. Just because the law and the statute says that you can't use money that's already being used for child support to calculate alimony, it doesn't mean that alimony should not be calculated. And I know that sounds confusing, but the bottom line is what they came up with was basically sort of a three-step formula for how to approach these cases where you have both alimony and child support issues. So usually that's where there is a significant disparity in income, and obviously there are still dependent children. And so what the court says is, look, you're not going to go back to the old way of just saying, okay, if all of the money is included in a child support calculation, then we don't bother with alimony. The court wants to make sure that we are doing an alimony or conducting an alimony analysis on cases where it's appropriate. And so the court says what you're going to do is you're going to first calculate alimony and take a look at those numbers and figure out what would be paid out in alimony. Then take the post-alimony calculations and plug those into a child support calculation to see what that would come out to. Then you can do the opposite. You can take the money and plug it into a child support calculation, and then take a look at the post-child support calculation and do an alimony analysis and see what that number looks like. And then you compare those two different results, sets of numbers, and you consider the tax consequences and the overall equities. In other words, take a look at all the circumstances and figure out which is the best way to do it and do it that way. So in a nutshell, you can't assume just because all of the income that the parties have is included in a child support calculation that it cannot also be used to calculate alimony and for purposes of an alimony order. So number one, calculate alimony first and then take post-alimony incomes and calculate child support. Then do it the opposite way, calculate child support first, take the post-child support incomes and calculate alimony, then compare the two, compare the equities, compare the tax consequences, and it'll be up to the parties to negotiate or the court to choose whichever is fairest and in the interest of the family. So that's the new alimony development in Massachusetts. This is a work in progress. It's going to take some time for us to really figure out what's going to happen with this. I wouldn't be surprised if it ends up going to the higher courts at some point, and maybe the higher courts issue a decision with more guidance on this. In other words, just breaking down further how this should work and maybe setting up some guardrails and boundaries for this. Because right now, I know that a lot of family law attorneys are concerned that this is going to cause some confusion. It's certainly going to require more work and effort to figure out how we can comply with this new decision. So if you have any other questions on this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social media at Farias Family Law. Thank you. Have a good day.